that language is not necessary, and to scandalize the good name of the speaker. It's not really necessary. And we pray for the court to visit the applicant with a post order, because scandalizing the speaker, the office of the speaker, and the president of the Senate, really, from members of parliament or former members of parliament, was really not necessary. Before I conclude, may I just get some instructions on other legal practitioners? These will be our submissions.
Thank you. Thank you very much, Council. Mr. Kanigwa.
Thank you, Lord. Lord, my duty is to be a in light of the amendment to the draft order by an amendment. I want to, in light of the amendment to the draft order, there is no relief that is sought against the third respondent anymore. And in view of that position, the third respondent will elect to abide by the decision of the court in this matter. I will end there.
Thank you.
My Lord, I'm indebted to my colleague for the second respondent that has brought to my attention that perhaps my attempt to amend the draft order was not as thorough as I intended it. The intention was in effect to clarify that relief is being sought against the first respondent, and anything against the second and third respondent is being abandoned. That includes paragraph 7 of the draft order, which relates to the second respondent. My sincere apologies, my Lord. This was addressed in the answering affidavit, and this is the intention of the applicant.
So we are withdrawing everything against the second and third respondent from your draft orders.
Indeed. In respect of the substantive relief, even as will appear from the final affidavit, it is the first respondent that is being sued in this application, my Lord. And that brings me to my response to the submissions by my colleagues. My Lord, I wish to take the court back to the draft order to clarify and solidify the relief that is being sought by the applicant. My colleagues for the first and second respondent have come up in arms in defense of the second respondent. And I wish to simply highlight that it is not the speaker who is being sued, and there's no relief being sought against the speaker. The question of the speaker's role and duty to uphold the Constitution and a certain standard of behavior.
They have the right to say that because your draft order is replete with allegations, rather orders that you want against the presiding officers of Parliament.
Indeed, I do accept.
And now that we have said, we categorically said we are withdrawing every paragraph that sits an order against the presiding officers of Parliament, then they must be good.
Indeed, my Lord. I do acknowledge that adjournments were made with regard to the Speaker. However, my submission is that the draft order itself seeks relief against the first respondent, and in particular to invalidate the letter that was written by the first respondent. That letter by the first respondent purporting to act on behalf of the political party is, with respect, the only issue before this honorable court. As per my earlier submissions, my Lord, while the role of the speaker and the consequence of his actions may be an interesting subject for debate, it is not the case that the applicants have brought before this court. And interestingly, the first respondent.
So you were doing it for interest sake.
My Lord, I do not abandon the submission that once the speaker has taken up a constitutional role, he is bound by the constitutional principles and is ought to act as an administrative authority that applies his mind. However, as I said in my earlier submissions, once that letter to the third respondent had been written by the speaker, that aspect of this matter is neither here nor there. And the heart of the matter.
You want to respond to his point. You said Section 129, 1K of the Constitution is a complete book on its own.
Indeed.
And you cannot seek to import other sections of the Constitution into it.
Indeed. My Lord, we do not seek to import other sections of the Constitution to it.
You intended to import Section 168, 68,
To
the
68.
administrative justice issues.
That is with regard to the role of the speaker. However, as I am trying to do in these submissions is to bring us back to what the applicant is actually seeking. And the applicant's assertion is that Section 129K of the Constitution has not been properly invoked. And that means the role of the speaker does not come into play in this question. The first respondent simply has one case to answer. Where is your mandate for authority to speak on behalf of the political party? And where is your evidence that the applicants have ceased to be members of the state? That is all that this application seeks to address. That is what it is about. And unfortunately, the first respondent submissions completely miss that aspect. Even in the papers, there is no evidence of any authority. There is no evidence of any cessation of membership. That is the first part of Section 129K. Before we start to speak of the validity or otherwise of the speaker's actions, we speak of the validity of the first respondent's letter. This is what the applicants seek to interdict. This is what the applicants are asserting is an act of fraud. Once that allegation has been made against the first respondent, the onus shifts on him to say, this is what based my actions. What is interesting, my Lord, about the first respondent's submissions is he is the first one to cry and say, call the political party to come and speak for itself. He says the political party must come and speak for itself. That is the exact concession that I'm speaking to, my Lord. He has accepted that he does not speak for the political party. He is on a frolic of his own to remedy issues of his own. But the position of the political party with regard to the applicant is common cause and undisputed in these proceedings. That the applicants were elected as members of parliament and of the Senate respectively under the ticket of the political party is not disputed. The letter from the president of said political party, who has been acknowledged in the submissions of both the first and second respondent, is not disputed either. My colleagues wish to hammer on the issues that have already been resolved by this court. It is accepted that the speaker has no role to adjudicate in the internal affairs of the political party. Those internal affairs are being brought before this honorable court. And the applicant, as the affected members of these purported reports, are saying we do not know the first respondent, and he has no authority to speak for us. Our membership has not ceased, and Section 129K of the Constitution has not, in fact, been invoked. That is the question before this court, and that is what the entire draft order speaks to, the validity of that particular letter. And as I have submitted, my Lord, and I do not wish to overly admit the authority on this point, once that allegation has been made, the onus shifts on the first respondent to prove his mandate and to prove the so-called cessation of membership, which is wholly denied by the applicant. Once it is accepted that he cannot speak for the political party, once he has admitted that he is not the political party, and in fact has said where is the political party? He accepts that it is not myself. The inquiry need not go any further than that point, as it is his letter that is being impugned. And to speak to the issue on jurisdiction, this is an application for a declarator and an interdict against the first respondent. The allegation is fraud. With respect, annexures ST1 and ST2 relied on by the first respondent are equally fraudulent, and in fact do not speak to any mandate relating to section 129K of the Constitution. It is denied that he is a member of the political party, and it is denied that he has been mandated to act for the political party in any way, shape, or form. ST1.
He did so in response to the annexures that you had also filed. You filed in annexure, I'm not sure whether it was PD1 or what, but it's one of your annexures in your application, where you then attached a document that was authorizing some people to countersign the nominations of candidates in the election.
Indeed.
That doesn't speak to 129K, does it?
Indeed. However, that document
And that's when the first respondent also filed a document countering that attachment that you had made. But you are right, both those documents are totally immaterial because they don't speak to 129K.
Indeed, my lord. However, the important acceptance by the first respondent is that those documents were authored by the leader of the political party concerned. And he accepts that he does not speak for the political party itself. I do agree with his lordship that those documents are not what speaks to the nub of this case. In those documents, it's sought to dispute the membership or otherwise of the first respondent, but it is admitted that even if the first respondent is a member of the party, and even if the first respondent was assigned to sign nomination papers for some members, he does not have the mandate to act for the party in terms of section 129K. That is the mere case that is being made by the applicants. And there is nothing that the first respondent has furnished to this court to
Like I indicated to you earlier, the only issue that I want to clarify is who does.
My lord, it is the appointed president of the political party who then wrote to the speaker.
So your point is that the CCC party spoke in this application through the letter that was written by.
Indeed, my lord. Indeed, my lord. And the action emanates from the applicants themselves, because the applicants have no reason to sue the party. They're saying the party is not the one that expelled us. The party is not the one that has seized our membership in any way, shape, or form. They, in fact, have no relief against the party at all. They're saying that this is a stranger who has forged documents and is purporting to seize our membership, which membership, at least at the point of them being elected, is an issue of common cause. And so this is why I submit respectfully, my lord, that once the first respondent claims that there's been a cessation of membership that nobody else knows about, it is up to him to prove his mandate to have seized such membership. And there's no such evidence that has been brought before the court. And accordingly, if we limit ourselves to the actual relief being sought against the first respondent, this is a very simple case, which in fact has been admitted by the first respondent. It's also admitted by the first respondent when he makes the call to say, let's bring the political party. What does he do? He distinguishes himself and his actions from it. And this is why I say, my lord, that this case needs go no further than that particular aspect, because we cannot have section 129K involved when the political party has not said anything to change the state of membership of its applicants. My lord, I think this addresses the preliminary points, but out of the abundance of caution, I just wish to address the second respondent submissions. I do understand where they were coming from in the need to defend the second respondent's position. And I wish to clarify that the office of the second respondent it was never the intention of the applicant to disrespect the same. The paragraph refers to where there's an allegation of scandalizing the second respondent. I wish to clarify that this is fully directed at the first respondent. What this paragraph says is that the second respondent has turned a blind eye. And this relates to the submissions on the duty of the speaker, which I've accepted that do not actually extinguish the case that is before the court. And so for
Did
that,
you assist in the drafting of the founding agreement?
no,
Who did?
my lord, it is I must state it is it's a team effort which involves a
But you
variety
agree,
of.
counsel, that some of the language used today is completely unacceptable.
My lord, I can agree to the extent that it was unnecessary for the purposes of these proceedings, and I think it stems from perhaps passionate but misplaced passion in this case, which is why I've not sought to justify what appears, but simply to clarify that if there is any indignance, it is really directed towards the first respondent. And perhaps the applicants felt, whether correctly or not, that a constitutional office such as the Speaker ought to also have maybe given due consideration to the two letters that were before him. However, as I've accepted in my earlier submissions, the issue of the letter having been written before the letter by the leader of the political party came, it affords the Speaker the benefit of the doubt. And again, it is neither here nor there in determining the question of whether or not Section 129K was properly invoked.
Thank you, counsel.
Indeed, my lord. With that, perhaps I feel it is appropriate to extend apologies to my colleagues as well as the respondents and to the court, should any of the language have been intemperate for the purposes of the proceedings. However, it stems simply from a cry from the applicants that their own rights should not be so easily altered by the actions of one man.
I thought you were extending an apology.
I will confine myself to the apology, my apologies. Indeed, my lord, those would be my submissions, both in response to the points in limine and rebuttals on the merits.
Thank you.
Okay.
Mr. Willie is clear.
Later, they think he's forgotten me.
Wow.
No, he said it to be forgotten.
My apologies,
Later, they intend to be free. Later, my very friend, Advocate Murili, submitted that we are alleging that Parliament failed to fulfill a constitutional obligation. Well, with respect, those are not our submissions. We have recourse to the relief that we are seeking. We are clearly seeking a declaratory and consequential relief arising from the first respondent's actions. So much so that, my Lord, even if you were not inclined to grant relief against the second to third respondent, we will be quite happy with you granting an order as against the first respondent. Once the actions of the first respondent are declared unlawful, everything else falls away. Well, my second submission relates to your most important question. Who does this record? Who should? Who did? the simple question, answer my list to that question is that the political party does advise the Speaker and the President of the cessation of members from the political party. But the point is made in our papers, my lord, that it is not the political party that did so. I need not belabor that point, my lord. But what is also clear, my lord, from the papers that I have before you, this has not been denied, is that the actions of the political party themselves are not complete without the actions of the Speaker and the President of the Senate complete the matter that is before you. It becomes important, my lord, and that has not been denied, that before the Speaker and the President of the Senate were two positions from the party CCC, which were in direct conflict with each other. As if to suggest that there is one CCC which the first respondent purports to be the interim Secretary General of, and another to which Advocate Nelson Chamisa was the president. Those letters were before the Speaker and the President. But on what basis did the Speaker or the President act on the letter by the first respondent? They could only have done so if they were making a decision in respect to both positions that were before them, which my lord we submit was incorrect for them to do so. And in doing so, they were not acting in terms of section 129, 1K of the Constitution.